Welcome everyone to the latest Wolfstorff Rosenthal webinar series. My name is James Pinedo. I am with the WR Knowledge Base. Today we're talking about the H-1B toolkits for employers, particularly consular processing versus change of status. Just real quickly to note, a legal disclaimer that this does not constitute legal advice and is for informational purposes only. For legal opinions, please schedule a consultation with one of our attorneys. We have a wonderful presenter for you today. Ms. Jane Lee, a senior associate with the firm, has over a decade in immigration practice. She possesses comprehensive experience with various corporate immigration legal matters, as well as family-based U.S. immigration. She is currently a senior associate at the New York office and sits as a member of Wolfstorff Rosenthal's Innovation Committee. She has a wonderful presentation. We'll let her take it from here. Ms. Lee.
Thanks, James. In today's webinar series, I'll be discussing H-1B toolkits for employers, specifically relating to consular processing and change of status. We'll be looking at what is consular processing, what is the process for consular processing, what are the disadvantages and advantages of consular processing, and then we'll be discussing change of status. What should I consider when electing change of status, and what is the process? Consular processing is applying for your U.S. visa at a U.S. consulate post in your home country. Or if you are outside of the United States, the default option to enter into the U.S. is through consular processing. Please note, if this is the case for your petition, once you receive the H-1B approval and visa stamp, you may not enter the U.S. more than 10 days prior to the date mentioned in the approved H-1B. What is the procedure and processing times? Well, the procedure is the same as if we were to file any H-1B petition, meaning that we would file an I-129 form, the H supplement, and data collection documents. We also provide similar support documents for the H-1B petition, which includes the support letter, certified LCA, academic degrees and transcripts, and petitioner's documents. In regards to the processing times, there are two. There's regular processing, and that is dependent and varied on the USCIS Service Center. It can take about a month to several months before the case is fully adjudicated. However, for premium processing, USCIS has to provide us an initial response within 15 calendar days. This can be an approval, an RFE, which is a request for evidence, or other notices. Either the employee or the employer can elect for the option, and the USCIS filing fee is $2,500. Once H-1B petition is approved through consular processing, the I-797 approval notice will not have an I-94, meaning you were not given automatic H-1B status in the US. I provided two samples of an I-797 approval notice. The one on your left is an H-1B consular approval notice without an I-94. The one on the right is an H-1B change of status and extension of stay approval notice. As you can see, USCIS granted an extension of stay by providing an I-94 on the bottom left side of the page. What are the advantages and disadvantages of consular processing? Well, first and foremost, with the advantage, you can control the date of the H-1B activation. Why is this an advantage? Well, for example, let's say that you're currently in an L1 visa status and your spouse has an EAD work authorization. Then you may want to utilize consular processing as you can decide on when to activate the H-1B. Remember, unless the principal applicant has an approved I-140, the H-4 EAD, which is also the dependent spouse work authorization, is not available. In order to gain H-1B status, you will need to activate your H-1B status. How do you go about doing this? You will need to depart the United States and schedule a visa appointment at a U.S. consulate, typically in your home country, for the H-1B visa stamp. This is called H-1B activation. Then, you can re-enter the U.S. on an H-1B status, and upon re-entering the U.S., you will be given an electronic I-94 approval departure number. So what are the disadvantages? Well, if you depart the US while H-1B change of status extension of stay is pending, USCIS will consider it to be abandoned. USCIS will approve the H-1B, however, deny the change of status extension of stay since you left the United States. This is called a split decision. Therefore, you will need to get an H-1B visa stamp before entering the US in order to work for the petitioning employer. COVID-19 pandemic and the effects on traveling. Due to the pandemic, many US consulates are not taking routine visa appointments and working at minimal capacity and enormous delays. If you are entering the US from a travel restricted country, you'll be required to obtain a national interest exception approval or quarantine for 14 days in a non-restricted country before entering the US. Presidential Proclamation 152 has also been extended to March 31st, 2021, which in part states new visa issuances are suspended. COVID rules are always changing, so please reach out to your attorney for up-to-date travel guidance. And lastly, there is a possibility of H-1B visa denial. Even though the H-1B is approved, there is an additional step of scrutiny with the reviewing officer during the interview process. Large discretion is given to the officer in granting the visa. What is change of status? Change of status refers to a person who legally entered the US in one non-immigrant status and wishes to change to another non-immigrant status without having to depart the US during the process. Change of status happens automatically. For CAP H-1B CAP purposes, timely filed petitions that have been approved will have an employment start date of October 1st on their I-797 approval notice. October 1st is also when the employee status automatically changes from their current status, for example, the F1 OPT, to H-1B, and will receive an I-94 extension. What happens if my OPT expires before October 1st? If this is the case, you may be eligible for CAP gap extension. This allows you to remain in the US and continue work authorization for the petitioner. However, please consult with your Woolsworth-Rosenthal attorney regarding CAP gap. So once you receive the H-1B change of status extension of stay approval notice, what happens next? Well, as previously mentioned, you may continue to work for the employer without disruption. However, what happens if you travel outside the US after receiving the H-1B change of status approval? Then you will need a new visa stamp, an H-1B, to re-enter the US. Therefore, you will need to secure a visa appointment with the US consulate post in your home country. You will have an interview with the consular officer, and upon approval, you will receive an H-1B visa stamp in your passport. This new visa stamp governs your entry into the United States. Please reach out to your WR attorney for additional documents you should carry with you on your interview. We would like to thank you for your time in watching our H-1B Toolkit for employers on consular processing and change of status.